practices to make sure that employees became familiar with the program. And the first order of business with regard to implementation of the law was employee and employer contributions. The law allows the program to be funded by both employers and employee contributions. Currently, contributions are 0.75% wages, and that's split approximately 50-50 between the employer and the employee. In September, we sent out employee notifications of the contribution and the opportunity to acknowledge or decline to acknowledge the notice. And contribution deductions began on wages paid on or after October 1st, 2023. The contributions are submitted by the employers quarterly, and that started. Next slide, Melissa. So, when we started to look at implementing the paid family medical leave law, we realized that it would be a missed opportunity not to look at all of our leave administration as it relates to employees who need leave due to an FMLA-related reason. As a result, the HRD PMO set up several work streams to focus on all aspects of PFML implementation, as well as the larger issue of leave administration. There are 6 scrum teams made up of 54 participants across the 9 secretariats and the governor's office. Teams meet weekly, engaging in 2-week sprints, and the status and accomplishment for each team are reported out at the team captain meetings, which are held bi-weekly. At that meeting, team captains coordinate their efforts with the other teams so there's a cohesive approach. Finally, there's a report out to the Executive Steering Committee with members from the HRD, the Governor's Office, A&F, ES, and the DFML. The Executive Steering Committee here's the status of what the scrum teams are accomplishing, and this is the form in which decision points are brought for approval and implementation on any recommendation. So what is the Paid Family and Medical Leave Program? The program provides temporary income replacement to eligible employees who are welcoming a new child into their family, are struck by a serious illness or injury, need to take care of an ailing or ill relative, and for certain military considerations. As you'll see as we go through this training, this law shares many similarities with the federal FMLA and our collective bargaining agreement. But there are several important differences. One thing to remember is that the PFML does not supersede the FMLA. The benefits can run concurrently when possible, but we are not alleviated of all the notices under the federal law. In addition, the PFML provides for both job protection and wage replacement. As we will talk about later in greater detail, employees can choose to use their accrued leave on PFML. So while an employee might not be taking advantage of the wage replacement aspect of the law, the job protection under this new law would still be available. Okay, next slide. So we'll start to go through the law itself and some important nuances. So moving to covered individual and employer. So these are 2 things that are defined specific to this law in a different way than we've typically seen. A covered individual is a term that's used in this law, and it's different than what we typically see in the FMLA. In many places, the PFML benefits are available beyond the traditional employer-employee relationship. Under the law, benefits can be available to certain contractors, the self-employed, and employees who have separated from an employer. For our purposes, as the Commonwealth as an employer, when you see the covered individual, you should think about anyone who receives a W-2 from the Commonwealth. So going to the definition of covered individual. So it would be, just a quick note, if everyone could mute their microphones, that would be great. I'm getting a bit of feedback. So the mute button is available at the bottom of your screen. If you hover your mouse over the bottom, it's a picture of the microphone. If you just click on that and it'll become red, and you'll know your microphone's good.
Michelle, just give me 1 minute to get back to you. Okay, Michelle, you should be good to go.
Great, thanks, Melissa. That's much better. Covered individual, as an employee, is someone who's earned at least $4,700 in the previous 12 months. And it's not specific to a particular employer. This is something new that we're all going to have to get used to. This means that someone could have earned $4,700 in a prior employer, and then on their very first day of employment with us, if they need to take PFML leave, they could do so. So this is far more generous than what we're typically used to seeing under our collective bargaining agreements, which had been the probationary period, or the Red Book, which was 3 months. In addition, it's far, far greater than what's required by the FMLA, which is having to work 1 full year and 1,250 hours before there's eligibility. So this is a new nuance that we're going to have to pay quite a bit of attention to. In addition, if we could go back. Thank you. This covered individual is also considered a former employee. So we can have someone who's separated from our employment, but then opt for benefits under this program through the Department of Family Medical Leave and receive payment. Further, the definition of employer is very liberal. If you have 1 employee or more, employers are subject to this law. So it's going to be broad, and it's covering both the public sector and the private sector. So as you'll note, the reasons for leave under the PFML are very similar to those under the Family Medical Leave Act. For family leave, it's 12 weeks to bond with a child within the first 12 months of birth, adoption, or foster care placement, a qualifying exigency related to active duty, or an impending call for a family member, to care for a family member who's a covered service member, which is 26 weeks, or to care for a family member with a serious health condition. In addition, under this law, individuals with their own serious health condition can take 20 weeks of PFML. What will add to the complexity of administering this leave are some of the different tasks I just mentioned. So tracking this leave will be very important moving forward. Next slide. Within the new law, the definition of family member is different than what we're used to as well. So typically under the family medical leave, we only have to provide leave for an employee whose spouse, child, or parent has a serious health condition. This has been greatly expanded under this law. We now have to cover those instances involving domestic partners, parents of spouse or parents of domestic partners, grandchildren, grandparents, which are the parents of the covered individual's parents, and siblings, which are the biological, adoptive stepbrother or sister of the covered individual. Domestic partner has been defined within the law as well. It's a very broad definition, and I think there'll be a lot of cases where it's clear who qualifies as a domestic partner. However, in many cases, I think we'll have to look to the definition and see and weigh whether the factors are met, which are common ownership of real or personal property, common householding, children in common, signs of intent to marry, shared budgeting, and the length of the personal relationship of the covered individual. Another thing that we can look for is whether there is a registration as a domestic partnership in any registry of domestic partnership. So, have there been any questions? I haven't seen anything in the chat. Let me release. Hey, Patrick, I am unmuting you, and have you seen
Any chat
So
in the...
we do have a question from Deirdre asking, what if someone is on FMLA?
Okay, so if an employee is currently on FMLA, the Department of Family Medical Leave we're still waiting for guidance on exactly how that will be handled. After January 2021, if an employee goes out has a qualifying condition that's both covered by the FMLA and the PFML, we would run those benefits concurrently.
We have another question. Can employees use this leave to care for someone with COVID-19?
It would depend. So the laws involving COVID-19 at this moment in time are set to expire on December 31st. And this law, the earliest someone could have leave to take care of a sick family member would be July 2021. So I don't know that I'm hopeful and will pray that there's no overlap of those two situations. But let's say there was. So if we're in July 2021 and that's still a situation that's the situation that comes about, the family member would have to meet the definition of serious health condition under the law.
Great, thank you, Michelle. We have another question in terms of tracking. So the Department of Family Medical Leave and the agency would both track the time used. Is this correct?
The agency will be responsible for tracking the time used as far as our internal employment practices are concerned. Because there will be many cases when an employee is opting to use our benefit and not that of the department. So that's something that we're going to have to do. The department will be monitoring and tracking its own implementation of the whatever it's paying out to individuals under its law.
Thank you. Another question from Kathy. Must the employer be a Massachusetts employer? For example, if the employee made $4,700 with a New York employer in the previous 12 months, would they be covered?
So my understanding is that it does need to be with a Massachusetts employer, and they would have had to make the appropriate contributions under the program.
Great, thank you. And another question from Donna. What is the time period in which a former Commonwealth employee can apply for PFML?
So it would have to be after the law goes into effect, but once the law is in effect, I believe they have 6 months.
Great, thank you. And one more question, would an employee be able to use this to offset an industrial accident?
Yes, there are some specifics in the law about the utilization of the interplay between workers' comp and the PFML.
Great, thank you, Michelle. Those are all the questions we've got at this point.
All right, moving on to the next slide. Employee notice to the employer. Like the FMLA, there is a requirement in this law that employees provide 30 days notice as soon as practicable if the delay is for reasons beyond the employee's control. The notice must include an anticipated leave date, the anticipated length of leave, the type of leave, and the individual's expected return date. Failure to comply with the notice requirement may result in leave being delayed. And when planning medical treatment, employees must consult with the employer to make reasonable efforts to avoid disruption to employee operations. One thing to note is the Department of Family Medical Leave has been very amenable to making it a requirement that an employee certify to them that the employer has been noticed prior to filing for benefits. So that will be a consistent precedent where an employee will have to come to us, let us know that they have a need to take leave prior to an application being accepted by the department. Next slide. So as I mentioned before, there is a lot of consistency or with what we currently see under our CBAs and the federal law with regard to the overall length of leave. As we all know, we provide 26 weeks of leave for our employees. We don't have it specified within our CBAs or the Red Book how individual caps as to how long somebody can be out for a particular reason. We have caps with regard to how much sick leave somebody can use for a family member, but other than that, we don't have, we haven't put any restrictions on the availability to be out for a particular reason in the original 26 weeks. Under this law, medical leave is allowed for 20 weeks, which is for the employee's own illness. One thing we're going to have, and then family leave is 26 weeks for covered service member, which is true under the FMLA, and then 12 weeks for all other reasons. So the birth, adoption, foster care placement, the exigency for military reasons, and the sick for a family member. One thing the law notes is that there's no spouse aggregate, meaning that if both spouses work for the Commonwealth, both employees can take the leave. So one thing we're going to have to be thoughtful about is the possibility of the stacking of benefits, because although we are incredibly generous, I think there are some ways where employees who are experiencing a number of different types of reasons to be out could expand beyond the 26 weeks in this law. And we're working through collective bargaining to try to minimize that impact. But for example, if you have an employee who needs to take 12 weeks out for a sibling who's ill, that's covered by the PFML. It's not covered by the FMLA, so we wouldn't be able to run the FMLA concurrently in that respect. So when, let's say that same employee needs to take time off to take care of a child, that is an FMLA reason. So at that point, we could run the two concurrently. So now we've got an employee who's been out for 24 weeks for two different reasons. Well, let's say then that person gets sick. They could still have time under the PFML for themselves. And so there is this capability where we could have a situation where somebody could be out beyond the 26 weeks anticipated by this law and the CBAs. So, again, that's something we're trying to deal with through collective bargaining, and hopefully we'll get to a point where we can safely work within the confines of the laws, the two laws, and the CBAs, and have as much consistency as possible. Next slide. So one thing that's very different, so far all of to date, the FMLA is technically an unpaid leave. We permit employees to utilize their leave balances to get paid under the FMLA. The PFML, as I mentioned before, has a job protection leave component, but it also has a wage replacement leave component. The weekly benefits are calculated on a percentage of an employee's earnings. Weekly benefits may be different for each individual. The maximum weekly benefit is $850 per week. So employees who make more than $67,000 will receive the maximum of $850 per week. And it is prorated for intermittent absences. There is a leave benefits calculator in the workers' guide on the Department of Family Medical Leave website that can do a calculation for an employee based on their own salary. It's a great tool. So if you have employees who in the short term want to understand what type of benefit they would be looking at and they earn less than $67,000 a year, we should encourage their use of that calculator. Next is the benefit year. So the law defines the benefit year as the 52 weeks 52 consecutive weeks beginning on the Sunday prior to the first day of job protected leave. So this is very different than what we do today. We have traditionally used the look back period when determining whether or not somebody has utilized their allotment of the FMLA. So that's something we're going to have to change. One reason we had used the look back period is it did prevent stacking. That's something that we're going to have to think about moving forward as well. So I'm using this forward-looking method. The next 12-month period would be the first time there's an FMLA leave that's taken after the completion of the prior FMLA 12-month period. So, for example, an employee whose leave begins on November 6, 2021. So the first 12-month period would start on November 6, 2021, and it would be through November 5, 2022. So on November 6, 2022, there would be a new benefit year and new 26 weeks of PFML would be available to the employee. However, if an employee didn't take leave until, let's say, December 1st, that would be the start of the next year. And, you know, using this forward-looking methodology, it could lead to stacking of benefits, but we'll cover that intersection of leave later in the presentation. Are there any questions?
We don't have any questions in that room.
Okay. So the next four slides are very similar to the FMLA, and the regulations were adopted to be as consistently as possible to the FMLA. So we'll just go through these pretty quickly. So the serious health condition standard is the same as the FMLA. We need to have an illness or injury or mental or physical condition that involves inpatient care in a hospital, residential, medical facility, or continuing treatment by a healthcare provider. Moving to the next slide. A healthcare provider is essentially the same as what we've been seeing under the FMLA. One thing that's new is that midwives are recognized as healthcare providers, so an employee could provide a medical certificate for a midwife. Moving to the next slide. So inpatient care is defined the same as in the FMLA, an overnight stay in a hospital, hospice, or residential medical facility, including any period of incapacity or subsequent treatment in connection with such inpatient care. Next slide. And then continuing treatment by a healthcare provider is a period of incapacity of more than 3 consecutive days. Treatment 2 or more times within 30 days of the incapacity. Treatment which results in a regimen of continuing treatment under supervision of a healthcare provider. Pregnancy, chronic conditions, permanent or long-term conditions, or conditions concerning multiple treatment. So, you know, one nice thing is that we're all up to speed on the current standard under the FMLA, and other than adding in accepting medical certification from midwives, most of the other standards remain the same. The PFML does allow leave on either an intermittent or reduced leave schedule. It can be by agreement when, for the reason of bonding after birth, or placement, or adoption or foster care. When it's medically necessary, so the healthcare certification would need to support the need, and that would be for a family member who's a covered service member, to care for a family member with a serious health condition, or for a covered individual's serious health condition. And then intermittent leave is always available for, just due to the nature of the leave, the qualifying exigency out of a family member's active duty or notification of impending call or order. The Department of Family Medical Leave is still determining some of the rules around how it will implement intermittent leave. And there to date has been a provision in the regs, and I believe it will stay in, that if an employee is on an approved intermittent PFML and they fail to come to work on an agreed upon schedule, an employee can be subject to discipline. So there is that carve out in those regulations for that purpose. Under benefit accrual, the law speaks to different aspects of what we are required to provide. Some of them are very similar to the FMLA. So leave periods where benefits are obtained through the DFML are not credited as service for purposes of time and benefit accrual, vesting, or eligibility for participate. Upon reinstatement, after taking family medical leave, it doesn't impact the benefit accrual rates or participation or vesting. Health insurance benefits have to be provided on the same terms as if the employee had continued to work during the leave. And one thing that is different, there is no provision to recover health insurance premiums for employees who don't return following their leave. When employees are being paid by the Department of Family Medical Leave, so they're not receiving a paycheck from the Commonwealth, they're only receiving the benefit from the Department of Family Medical Leave, they're going to be considered to be on an unpaid status by the Commonwealth as an employer. Therefore, all the regular rules for an unpaid status will apply. One important thing to note is that due to the unpaid status, at the time the employee is receiving their paid PFML benefit, that time won't be considered creditable service for retirement. Next slide. And then, similar to the FMLA, there is a provision that after taking the PFML, an employee should be restored to their previous position or an equivalent position with the same status, pay, employment benefits, length of service credit, and seniority as a legal age. And I don't think we utilize it much here in the Commonwealth, but the FMLA provides an exemption for restoration for highly compensated employees. And that is not something that the PFML has outlined in its law. So why don't we stop here for questions?
Thanks, Michelle. We have a couple. Deirdre is asking if someone has the long-term disability benefit, how does that impact PFML?
So I think they're still working through the answers to that, and we should see more guidance in the regulation.
Thank you. And Sarah wants to know, how will the PFML affect the granting of catastrophic leave? So it would have to be a situation where an employee had not exhausted all of their so as I meant, and I think I mentioned this, and if I didn't, I apologize. So as many of the benefits will run concurrently as possible. So when an employee is taking leave, whether or not they're taking a paid benefit from the Department of Family Medical Leave, the leave benefit under all relevant laws will be running concurrently. So an employee could technically be out, let's say, for example, under the FMLA, the PFML, the Mass Parental Leave Act, all concurrently at the same time. And so we're going to have to be thoughtful about how we notify employees who are taking leave concurrently. In order to get to the catastrophic point, there would have to be a situation in which an employee hadn't utilized the PFML within the first 26 weeks of their absence. So I'm not sure how that may happen. I guess if it happens, the employee would be out under catastrophic with us while running concurrently with the PFML. I don't think that will happen in a lot of cases. Great. Thank you. Mary would like to know, how will EILD and PFML work?
So An employee could not receive both benefits at the same time. So an employee would have to elect to either exercise their rights under EILD or under PFML. And as I just mentioned, if an employee has taken time that's protected under both the PFML and but chose to be paid through the EILD, in all likelihood there wouldn't be any PFML paid benefit be available to them because they would have exhausted all the time under their initial absence while they were being paid under the EILD.
Thank you. Does all benefit time have to be exhausted to be eligible for PFML?
No. It's the employee's election as to whether they would like to be paid through the Department of Family Medical Leave and receive a PFML benefit or exercise the rights to our paid benefits under our CBAs or the Red Book or EILD. So it's the employee's decision to elect to go one path or the other.
Great, thank you. Next question, will deductions, GIC, 457B, union dues, etc., still be deducted when being paid by PFML?
No. An employee will be considered to be on an unpaid status by Commonwealth as an employer, so they would have to be direct billed in every respect.
Thank you. Next question, will PFML have its own certification form?
Yes, my understanding is that they are developing a form. My understanding is that they are trying to make it consistent with the forms that we use, that the USDOL has published to use for the FMLA. But it may have some additional information unique to their program.
Great, thank you. Can benefit time be used to make up the difference between the PFML amount and their normal salary?
My understanding is that the answer is no to that question.
Thank you, Michelle. That is all the questions we have in the chat room right now.
Thank you, Patrick. So we touched upon this a little bit and with just a few of the answers to the questions that we just chatted about. With regard to exhaustion of paid leave, an employer cannot compel an employee to exhaust any sick, vacation, or personal leave prior to or during a leave, but employees can choose to use their accrued paid leave rather than to apply for a benefit under Chapter 175M. Where if that does happen, employers are required to inform employees who choose to use accrued paid leave that such paid leave runs concurrently with the Chapter 175M leave period. And employees cannot get a paid leave benefit under Chapter 175M for the same time that they are paid, being paid with accrued paid leave. So there's no double dipping between the two. So, I just wanted just a little bit in the answers to the questions. So the PFML can run concurrently with leave taken under any applicable state and federal laws and relevant employee policies, including but not limited to the Parental Leave Act, our collective bargaining agreements, the federal FMLA, the EILD, and the Earned Sick Time Act. So it is it's our goal to leverage that ability to run as many laws concurrently with the relevant underlying needs for leave. Next slide. So just a few things to be aware of with regard to the PFML. Tracking time will become more complicated due to all the different leaves that are intersecting and the different reasons to qualify under each leave. Employees might use PFML for short periods of time, such as waiting for the 20 days for the EILD for short-term and long-term disability. As PFML covers family members that FMLA does not, employees may take leaves that are not considered concurrent but parallel and thus creating more time off. Just noting that benefits become available at two different times. So on January 1st, 2021, benefits are available for bonding with new children, managing affairs while an employee's family member is on active duty, and serious personal health conditions. On July 1st, 2021, the law goes into effect that allows employees to be out under this law to care for a family member with a serious health condition. In addition, what is new under Chapter 175M is an administrative review if benefits are denied. The denial of benefits can be appealed to the Department of Family Medical Leave. An employee or a covered individual can request a hearing, and an individual aggrieved by a Department of Family Medical Leave decision can appeal to a district court. In addition, in Chapter 175M, one provision that we need to be really thoughtful about because it's very concerning and it's a brand new concept is that the law creates a rebuttable presumption of retaliation if any negative change in seniority, status, employment benefits, pay, or other terms or conditions of employment occurs during the 6 months following an employee's leave. The presumption can only be rebutted by clear and convincing evidence that an employer would have taken the same action regardless of leave. And I fear that we will see a lot of cases under this provision of the law because included within the law is the ability for a court to order total damages and the payment of attorney's fees. And there's a 3-year statute of limitations. So what this essentially means is that if somebody's taken a leave pursuant to the PFML and something negative happens to them, that they went for a promotion and they didn't get a promotion, there's a presumption that the fact that they didn't get a promotion is in retaliation for taking the leave. Now, the law does say we can rebut that presumption by clear and convincing evidence. And so that's really what I want to focus on right now is clear and convincing evidence. This means we have to be very diligent in our documentation efforts surrounding pretty much any personnel action moving forward. We're going to be able to have to explain in a lot of cases as to why what we're doing was legitimate and why it was not retaliatory. In the regs, hopefully the Department of Family Medical Leave is going to be tightening up some of the terms that are used in this section of the law to give the employer the ability to, manage their organizations a little more freely. They can't do away with this provision, but I think they are going to clarify some of the aspects of what would be considered retaliation. But it is concerning, and I can't emphasize enough the need moving forward to practice good documentation anytime we take any sort of negative action against an employee who's been on leave. So then we have the training time frame. So right now we are working to provide overviews of the PFML law. In June, our training team is going to do fundamentals of supervising staff, and then moving forward, we're going to have different trainings with regard to some of the more practical aspects of implementing the PFML standard operating procedures and workflows and use cases. So by the time that we go live in January 2021, everyone is clear on their roles and responsibilities and how to implement not only the PFML, but all of our leave programs consistently throughout the Commonwealth. I think we went backwards. All right. That's all for questions.
Thank you, Michelle. Will employees be able to use PFML if they have a list of items to bank?
I mean, so again, the employees will be, any approved leave will run concurrently with any paid benefit. So an employee would be exhausting their job protection leave under the PFML, but being paid only through their legislative leave bank. There should be no case where the Commonwealth is paying an employee their full salary either through legislative sick leave bank, EILB, or either sick or vacation accruals, and they would also be able to get payment through the Department of Family and Medical Leave.
Right, thank you. Next question. Will employees be required to exhaust all eligible PFML time or withdrawing from EILB, or will they be allowed to use EILB over PFML?
So it will be the employee's choice as to whether they want to exercise their rights to an employer-provided benefit, whether it be sick, vacation, EILB if they're a member and have otherwise qualified for its use, or to go the path of receiving the paid benefit from the PFML.
Thank you. Next question. Will there be a new TRC code for the timesheet?
I believe they're working out the answer to that now. I don't know exactly how many or what that will look like, but we will have information in plenty of time.
Thank you. Next question. When will the department be notified of the time an employee has used under PFML?
So the nuances that are also being worked out. The Department of Family and Medical Leave is currently working with a great vendor who's creating a system. At some point in the future, the hope, as it's been explained to me, is that employers will be able to look up their employees' utilization and have sort of the ability to check in and see what employees have used. As I mentioned before, I don't know if that functionality will be ready on January 1st. I've been made aware of that. But what will be available to us right from the beginning of the program is that employees will be required to notice the employer prior to an application being received from the Department of Family and Medical Leave. Once an application is received from the Department of Family and Medical Leave, they will have an exchange of information with the employer. So they'll share with the employer what they know about the need for leave and then ask a certain number of questions from the employer. There's going to be a fairly quick turnaround time of about 10 days for the employer to get back to the department. When the department has a fully complete application, so that would be information from the employee, information from the healthcare provider, and information from the employer, the department will make the assessment whether or not the person qualifies for benefits under the program. At that point, we will be notified what the employee has been approved for. So we will receive that sort of outline from the department as to the leave has been, that the benefit has been approved, and also what the duration is for approval. Now, prior to this, we will have already jumped into we've been noticed by our employees that they have a need for a leave that may be qualifying for the FMLA. So we would already be doing our own process, sending out our healthcare certifications to employees, getting the information back, making the assessment as to whether or not there's a serious health condition. So we would have already had a look and have knowledge as to how long an employee would need to be out. And then the question is then whether how much of that would be paid by the department.
Great, thank you, Michelle. The next question I can actually answer. We'll read you forwarded a copy of the PowerPoint. The PowerPoint is attached to the meeting invite, so everybody already has it at this point. And as Melissa mentioned early on, this presentation is being recorded, and we will be posting it, and we will send out a link to everybody so that if you want to go back and review it, you'll have the ability to do so. And those are all the questions we have. Oh wait, I think I have one more. Let's see. Has there been any discussion among the working groups about the intersection of PFML and ADA leave?
Yes. So I'm the team captain of the Standard Operating Procedures work stream, and we have an ADA coordinator on our team, and she's very thoughtful about bringing issues to our attention. And we certainly will be including that avenue of how someone who has the need for a serious health condition, has the need to leave for a serious health condition and then comes back, how we would bring in the ADA coordinators to make sure that the employees are, fully aware of any rights or needs under that law as well.
Great. Thank you, Michelle. Those are all the questions we have from the chat room.
I just want to make, this is Melissa. I know we have a few folks that are called into this session. I know that you folks aren't muted, but does anyone that called into this session, does anyone have any questions that are on the phone? Okay. Oh, sounds like, did I hear someone? I don't think so. Okay.
Great.
Okay.
Well, thank you all. I really appreciate the opportunity to talk to you about this today. You'll be hearing a lot more as we move forward in the process. And if you have any questions in the meantime, please shoot me an email. I'd be happy to answer them. Sort of same caveat to the best that I can at this moment in time. But we'll have a lot more guidance come the summertime and be able to do this. Thank you for your time today.
Great. Thank you, everyone. Thank you, Michelle, and everyone have a wonderful day.
Thank you.
Michelle, thank you.